Ilya, we're very, it's our pleasure to have you today. And we're really excited to hear your expert thoughts on all of these Supreme Court cases. So, with that, take it away.
Well, it's great to be back with you. And it's exciting to see so many young people interested in the Constitution. Um, this was a term that had a lot of different aspects to it, and I'm glad that we're focusing on administrative law. A lot of the political discussion is about President Trump's immunity for various acts. There were a lot of social media cases as well. But this administrative law stuff, the rules governing the government, as it were, I think is the most important part of what the court did this term, and especially this case called Loper Bright Enterprises versus Raimondo that overturned the 40-year-old Chevron Doctrine. What Chevron did was, this is 40 years ago, 1984, it said that when an agency, meaning an agency of the executive branch, an administrative agency, part of the federal bureaucracy, it's all talked about, this is all the same thing, whether it be the Department of Labor or the Environmental Protection Agency or the Securities and Exchange Commission or the FBI, all of these federal agencies, okay, when one of these agencies interprets the law that authorize it to do things, what should courts do? How should they treat that legal interpretation or determination? So the EPA, for example, in Chevron itself, the case of Chevron, which is an oil company that involved power plants, and how they're to treat airborne pollutants under the Clean Air Act, right? So there was an interpretation made by the EPA, and the Supreme Court said that courts should defer to the EPA, or more broadly, to agency interpretations of their governing statutes, if those interpretations are reasonable. So courts don't need to figure out what the best interpretation is and make sure that the agency picked that one. They just have to make sure that the interpretation is reasonable. In other words, let's say you can interpret the law A, B, C, D, as long as you don't choose X, as long as you're not what lawyers call arbitrary and capricious, kind of crazy, off the reservation, then judges defer to what the agency does. And as you can appreciate, I'm sure, that means that agencies over the years, over the decades, have gotten a lot more power because courts let them do whatever they want as long as it's not crazy. Okay? So that's also shifted incentives in the government more broadly because Congress, seeing this dynamic, says, okay, we can just pass general laws, let the agencies interpret them, and if someone's upset with that, well, it's not no skin off our backs. It's the agency doing that, and then the agencies get sued. And so all of these big controversies that Americans are up in arms about, whether it's a regulation of healthcare under Obamacare, whether it's a Labor Department regulation that's hurting a lot of businesses, whether it's developers or individuals can't build something on their land because of the EPA under the Clean Air Act, Clean Water Act. Again, Congress says, look, we didn't do that. That's some bureaucrat over there. Go sue them. And again, that's why the Supreme Court and other courts have ended up having to decide a lot of these major controversies in American life. That's part of the reason why there are more protests and demonstrations in front of the Supreme Court than in front of Congress, which is an odd dynamic because Congress is supposed to be the place where we fight out our differences in values or policy preferences or what have you. So this term, the court said, no, we were wrong 40 years ago. The Administrative Procedure Act, which is the law governing, again, how the bureaucracy is meant to operate, does not allow courts to defer to the agencies. Courts are tasked with interpreting those laws. Now, there's criticism of this ruling in the Loper Bright case, which involved fishing regulations. I won't go into that because that's not as important, but it's partly based on the fact pattern in the Oscar-winning movie Coda about small fisheries having to pay for the federal regulators that sit on their boats monitoring them to make sure they're not violating fishing regulations. But anyway, setting aside those technicalities, there's criticism that, well, all of a sudden the court is taking upon itself the duty to become economists and scientists and evaluate, how clean our drinking water is supposed to be. Why are judges doing this? This is a power grab. And the answer is no. What the courts are doing is evaluating the law and the legal interpretations. They're not going to be second guessing, an EPA determination that you can have 5 parts per billion of arsenic in drinking water rather than 6. That truly is agency expertise. As long as the agency in making that determination is following some authority that Congress has given it to do, then they're going to be fine. It's about the legal interpretations because the lawyers at the agencies, the Supreme Court is saying, are no better than the judges who, after all, are tasked with enforcing the law. So that's the major case this term. There were several others that made this a term about administrative law. One is about when you can sue, because again, even with the most beautiful, perfect legal ruling, if nobody can sue to enforce those rights, that's not very important. So the court said that you can sue. There's a 6-year statute of limitations that you can sue after a rule is passed. Well, what happens if it's an old rule and your business is relatively new? And the court said, yeah, as soon as that business is harmed by that rule, you can sue. That's important. And another, that case was called Corner Post, and a case called Jarkissi, which relates to the internal determinations, the adjudications by internal, what are called administrative judges. So bureaucrats that act like judges within the agencies, in this case, in the Jarkissi case, the SEC, the Securities Enforcement Commission, and the Supreme Court said, no, if someone is being investigated and prosecuted and ultimately fined for a lot of money for violating the rules that the agency makes, that has to be subject to a jury trial under the 7th Amendment. We all have our rights to a jury trial. And so whether it's the SEC or another agency that has these internal judges, that's not good enough. The agency can't act as the legislator, the investigator, the enforcer, the judge, jury, and executioner. We have constitutional rights to protect people against that. So again, this term, I think, will come to be seen as a bit of a revolution, or at least a rebalancing of administrative law, the separation of powers, the rules that govern the government, the administration, the bureaucracy, all of those executive branch agencies. And that's really important because Congress has been legislating less and less. They've been allowing the agencies create more and more of the rules and the laws by which we live our daily lives.
Great. Well, thank you so much for that really comprehensive overview. And now I'd like to pass it over to Janine to kick us off with some questions.
Yay. Thank you, Ilya. That was really, you're one of our favorites. You're one of our favorite guests. But yay, it's coming back. All right. So I always think about the 7th grader that's listening to this. And over the past, over the past 14 years, since I was raised in a military family and, patriotic and all that, but I was an actress. And so I've had to learn all this legal and all these terms, through my 14 years of self-education with the Constitution. So for the 7th grader,
administrative law is particularly technocratic. So yes, please, if
Yeah.
there's something that I need to simplify, please do ask that.
No, you were very simple, but I thought, well, for the 7th grader, let's break this down a little bit. So initially our founders started 3 branches of government, legislative, the Congress, executive, judicial, checks and balances. Now, let me see, just let me know if I get this simplified in the correct way. Then Congress, who's supposed to make the laws, got tired of making all the laws and everything got to be too big. The country got huge businesses. They became overwhelmed. So they delegated their power to agencies like the Environmental Protection Agency and SEC and things like that, to handle things that they no longer wanted to worry about. But those people now, these agencies, they're not elected. They're not elected. And suddenly they're making all these decisions for the American people. That was really our founders intended that to be with the legislators. So they kind of got lazy, maybe perhaps as a way of looking at it, and gave it to the administrative state. The administrative state, that is people that are working, making all these decisions, but they're not elected. And that's the same thing as a bureaucrat. Am I right so far?
That's, yep.
Okay. All right. So then what started to happen is that the administrative state, which under utopian terms is you have experts dealing with this and they could be able to handle all of this and whatnot. But it became, as our founding fathers talked about, there was no check on them, and men are not angels, as they said in the Federalist Papers. So since men are not perfect and they're kind of power hungry, there was no regulator, there was no governing, there was no check and balance on these administrative states. So they started to gobble up a bunch of power and throwing out all these rules with no check or governor on them. Is that right?
That's right.
Okay. So these Supreme Court cases
and Janine,
were
just to be clear, this isn't supposed to be something that divides conservatives and liberals or Republicans and Democrats, because it's an issue of who writes the rules, not what those rules are. So the idea is we elect Congress, our elected representatives represent us, they debate what policies they want to have, and then the bureaucracy, these agencies are supposed to implement that policy, because nobody elected those bureaucrats. I mean, cabinet secretaries, the president whom we elect picks, but the bureaucrats, especially the ones who are doing the interpreting of these laws, nobody elected them. And so that's the problem of democratic accountability. Again, you could have rules coming from the agencies that conservatives would like or liberals would like. That's not the point. It's to be legitimate, to have a government by, for the people, we have to follow those kinds of constitutional rules.
So the administrative state is nonpartisan, but it becomes, well, men are not angels, so it became too powerful, right? And so the fishermen on the boats, this is a good example, and this is a Chevron case, but it has nothing to do with Chevron gasoline, does it? I mean, why is it called the Chevron case?
Well, the
Or does
original
it?
case 40 years ago,
Chevron-
and the original case 40 years ago did involve the Chevron oil company, yeah.
Okay, so it's still all right. So they had to have the administrative state, a good example, said that the fishermen, when they go out to fish, had to have one of these unelected bureaucrats on their boats, and they had to pay for that person to be on their boats, if I understand correctly. And they were hovering over them, watching them do everything they did and taking all these notes and whatnot. And they didn't like that. Is that part of is that just a really good example?
Yes. And even worse than that, that rule was not, I mean, the relevant agency, the National Fisheries Service, just made up that rule. It's not like Congress passed a law saying that you have to have federal monitors on your boats and you have to pay for them. The agency just made that up. And so that's what they're
okay. So
challenging.
that's a great example where the agency made something up, not the Congress, not the legislative branch. And then is the issue that the people didn't have any power then to fight that?
Well, they're being hurt. They're being forced to pay up, I think it was like $700 a day, which is a lot for a small fisherman on his boat, for this federal monitor. So he was being hurt. So he had standing to sue over this rule, making the argument that the relevant law about fisheries regulation didn't give the agency the power to issue this rule about paying for monitors.
And another aspect of this decision is that the courts became too lax. The courts were supposed to really keep a monitor and a governor on what these administrative agencies are doing, and they became too broad and they didn't hold enough accountability. Is that part of what this decision
Right. The
was?
Chevron doctrine is courts basically sit on their hands unless the agencies are doing something crazy.
So what does this new decision say the courts have to do? They have to be more accountable now?
The courts are supposed to be the ones who are interpreting the law. So rather than deferring or letting the agency have its way as long as its interpretation isn't crazy, you can ignore the agency interpretation and courts just look at the law themselves, which makes sense. Courts are supposed to be interpreting the law rather than rather than agencies doing it. Even if there's lawyers at the agencies, that's not the issue. It's that it's the court's job to review in our system of checks and balances, as you said, what other branches of government are doing.
So you said before this court case, the courts would look at the laws and say, if you're doing A, B, C, D, E, that's okay as long as you're not doing X. What are the courts supposed to do now that the Supreme Court has sort of reshuffled things?
Courts are supposed to figure out what the best answer is. So among A, B, C, D, E, what is the best answer? And if the agency didn't pick that best answer, they lose.
Okay. Interesting. All right. So in closing here, because I don't know where I'm on my time, I've got like 2 minutes. How would our founders feel about the administrative state? And it's funny, my daughter is conservative, and she's gone through 7 years of kind of Ivy League schools, and she emerged still feeling conservative in her kind of perspectives on things, but she loved the administrative state. She thought it was so interesting. You know what I mean? And I'm like, well, they got a lot of decisions going. So they must have taught her something about why the administrative state was so wonderful. So what do you think they taught her where they said the administrative state was wonderful, but also how would our founders perceive this and going forward?
Well, the founders were familiar with certain kinds of bureaucrats, postal clerks, for example, or we can think of it now in the modern era, the DMV clerks, right? We don't want to have to require state legislatures to vote on each individual's driver's license application. You know, we hire people to administer the laws in that way. So, you know, similarly, I don't think we necessarily want congressional committees evaluating all of the economic studies and you know, scientific studies to promulgate the rules. They can delegate some of those administrative tasks. That's why it's called the administrative state. It's not they're not supposed to be lawmaking. The Congress is supposed to say, you know, we want you know, clean water in this way. You can't just pass a law. This is a somewhat separate issue. You can't just pass a law saying we want good policy and we'll task the Defense Department with executing good policy. That's too broad a delegation. So they have to have specific laws, and you can argue around the margins of whether a particular delegation is too broad without articulable standards for what the administration is supposed to do. But you know, having a bureaucracy is not wrong. The problem is when the bureaucracy is the one writing the laws rather than simply executing the laws that Congress has passed.
So is that going to stop now that they can no longer write the laws, or are they still going to be writing the laws and they're just going to be interpreted more severely by the courts?
More the latter, if things are working right. You know, the Supreme Court decision doesn't require a lot of federal officials to lose their jobs or anything like that, civil servants, but it restricts the breathing room of the lawyers, let's say, in the Department of Labor, to make sure that they're actually doing what Congress told them to do rather than making up new law.
So the administrative state is who's supposed to really just sort of execute, make things happen, are now making their own laws, and so the courts
That's
are
right.
supposed to be
That's right.
more
It's people joke that it's
hands-on.
people joke that it's the fourth branch
Yeah.
of government, and the Constitution only authorizes 3.
Yeah. Huh. I wonder, I only have 10 seconds left, but you know, would that have been something Congress could have done differently when they created this administrative state, is to not give them the ability to make laws without approval from the
No,
congressional,
it's
the
more that the
legislative
courts
branch?
have it's more that the courts have allowed administrative agencies to get away with it. And so this court now this year are starting to pull back on that.
Okay. All right. Hey, thank you very much. I have to share. So now I'm going to turn it over to Tova and Jewel and Jorn. Thank you. Thank you, Ilya.
Thank you so much, Janine. I kind of wanted to stay on this topic of kind of like the unelected bureaucrats and administrative state because I guess I wanted to ask, is this case part of a more concerted effort to decrease the power of the administrative state overall? Because I've noticed I actually went to the RNC last week, and so many speakers were kind of hammering on this idea of like unelected bureaucrats and the administrative state and all of that. I read Project 2025 of the Heritage Foundation, and a lot of it is about replacing unelected bureaucrats with political appointees from the Trump administration if he wins a second term. So it seems to me that this has become kind of like a larger idea that this Supreme Court case is maybe just one step in that. So I was curious what your take on that was. Is this a larger movement? Are there next steps that will happen after this case? And also, as you said, it doesn't have to be a partisan issue, but it seems to me that it has taken a partisan tint. So obviously we're a nonpartisan organization. So, but could you give us like a more broad level overview of why this has become a partisan issue?
Sure. So the administrative state really has grown, and there's been this dynamic where as courts defer more and more, and Congress passes the buck, and so the agencies have gained more power. Um, it's become a partisan issue because a lot of what agencies do is growing their own authority, growing the government power, and in modern times, conservatives don't like big government as much as liberals or progressives do. And so to that extent, to the extent that it's a ratchet in the bureaucracy for ever expanding government power and regulation, that on balance, progressives like what the bureaucracy does more than conservatives would, and that's how it's become a partisan issue. But yes, it is part of a broader, longer term pushback on the growth of the administrative state. Um, that was a big focus of President Trump's first term, for example, with the nomination of Justices Gorsuch, Kavanaugh, and Barrett, who are all known as being skeptical of judicial deference to agencies, of agency growth in various ways. They were all in the majority in these cases that I just discussed. There were also other regulations that the Trump White House passed, like, for example, we said anytime there's a new regulation, two old ones have to be removed. Kind of a gimmick, but very popular to try to remove the red tape, things like that. And there's been a lot of scholarship in law schools by law professors about whether the bureaucracy has become unaccountable and what we can do to make it more responsive to political leaders and ultimately to the democratic process.
Thank you. And what do you think would be the next, are there next steps after this? In this,
The next big kind of high level legal battle is, I alluded to this in my discussion with Janine, over the scope of delegation by Congress to the executive branch, to the administrative agencies. That is, uh, we have this principle embodied in the separation of powers that one branch can't give its powers to another branch. So, like a court can't say, "I don't want to decide this issue. I'll let the president decide whether this person is guilty or not, or who wins this lawsuit." You can't do that. And similarly, Congress can't say, "This is too hard to legislate or would be politically too controversial. We will just pass the Truth, Beauty, and Goodness Act of 2024 and let each of the cabinet agencies interpret that as they will." That's too broad a delegation. So lawyers call this the non-delegation doctrine. At the federal level, no statute has been struck down or invalidated for violating this non-delegation doctrine since the 1930s. But now, with less deference to executive agencies, the next big battleground is, well, sometimes the laws themselves are so broad, so vague, that there's no law for courts to interpret. And at that case, that's a good sign that maybe Congress wrote the law too broadly in a way that there's no way for the agencies simply to apply the law or enforce the law, as we were discussing, rather than having to make new law in the first place.
that makes a lot of sense. Maybe we'll have you on in a few years to discuss whatever happens when inevitably there's another case on what you just articulated. Now I wanted to shift to talking about the judiciary, and to me, it seems that this decision has greatly increased the power of the judiciary. Um, And so I guess I have a few questions around that. Like, for instance, it seems to me that this will be kind of like an enormous amount of new litigation kind of headed towards the judiciary, since instead of having kind of like experts decide these issues or unelected bureaucrats, however you would choose to phrase it, in these agencies, those questions will now go to the court. So it seems like this will be a lot of new litigation at a time when the court system is already, my understanding is sort of understaffed and clogged up with cases. So how will there be more resources directed to the judicial system to deal with these new cases? Will there just be more of a backlog? Do you think they'll be able to be responsive with how busy they are? What's your take on that? And then I'm just curious about the broader implications of the judicial system becoming more powerful, because as you articulated, it seems like the judicial system also isn't always electorally accountable, particularly like the Supreme Court is appointed by the president, which is electorally accountable, but they're also unelected themselves. So I'm just curious what what the broader implications of a more powerful judiciary are, and how they achieve the
I'll
goals of
just
taking away power from unelected.
I'll just step in and say they do have to be, the Supreme Court justices do have to be ratified by the Senate, though, which you know that, right? So it's not just a presidential appointee. Did I understand what you were saying, Tova? Did I grasp that correctly?
Yeah, my question is about this decision increasing the power of the judicial system, um, and whether that's sort of what the founders would have wanted in their paradigm of the judicial system being the weaker branch.
Yeah, well, I mean, the constitutional structure contemplates judges determining what the law is. So it doesn't give judges the power to set policy. It gives them the power to determine law, and that's what the court was doing. So it's not a judicial power grab. It's saying, restating that judges are supposed to do their jobs rather than simply letting agencies do their jobs for them, in effect. Um, I don't know how much more litigation we're going to see, because one aspect of the Loper Bright decision and Chief Justice Roberts's majority opinion is that previously settled cases or litigation over previously challenged rules is not to be disturbed. So it's not like we're going to revisit issues that have already been decided under the old Chevron rule. So this is more forward-looking. It'll affect currently pending litigation. For example, a high-profile one right now is a challenge to the Biden administration's rules under Title IX, which relate to um, opportunities for members of both sexes in education, and how that relates to recreational facilities, sports, bathrooms, all of these various things relating to sexual orientation and gender identity. These kinds of issues. There was a long set of regulations enacted earlier this year that have currently been blocked by several courts. But now, as those decisions go up on appeal, the judges will not be able to defer to the education department in that context anymore in these cases, and anything going forward. So really, we might not see more litigation because the agencies will get the message and they won't go out on a limb, and they're going to do a better job of figuring out what the best answer is in terms of interpreting the congressional statutes they're supposed to be applying.
Do you think this will have an effect on the legislative branch, and they might pass maybe more comprehensive or explicit rules? Or with the state of Congress now, do you think this will just end up more shifting
That's
interpretive power
that's
to the
that's the
court?
incentive. And as I said, that's why the next stage is about the non-delegation doctrine. So, this was a message to Congress as well, to say, if you want an agency to do something, we're not saying you can or you can't, whether in the context of fishing regulations or anything else. But if you want an agency to do something, you're going to have to give it direct authority to do it.
But in your opinion, do you think that that's what we'll see from Congress, or do you think at a time when it's pretty divided and slow, that we might not get that?
I mean, at the margins, I don't know. Congress isn't very good at doing anything other than naming post offices and passing a very rushed budget every 2 years. So, um, if we ever break a log jam and one party or the other has a sufficient enough majority, I'm sure they will try to act with more specifics than they would otherwise.
Makes sense. Well, thank you so much for answering my questions, and now I'll pass on to Jewel and Jordan.
Hello. This discussion, of course, is wrapped up in really how we see government as a whole, and I think that sometimes we look at modern government, it's hard to wrap your head around because we expect so much of our government, and we want this efficiency, we want the ability for them to do things well, but we look back at our founding, and they had many different principles. I mean, many of their principles were primarily protect the rights of the individual first, and almost set up roadblocks for the government to be able to infringe on those rights and make sure that was really, really hard. So it's hard when we look at the case first to just be struck by the administrative state was able to have enough power to place a human being on every single fishing boat and then force the fishermen to pay that human being while they looked over their work. So it's hard to, and then that went to court and got taken down because of something in the law that the way you described it elegantly about how the minute they did not have the power to do that and not have to defend it being reasonable. So the court has the power again to say whether or not it's reasonable. We're not just going to defer to the administrative state saying that if they think it's reasonable, then it's reasonable. Well, taking it just back one more step, they still have the ability to place a person on these fishermen's boats. So I'm a bit struck by that. Just wanted you to kind of comment on it. I mean, that seems very, very far from our vision of life, liberty, pursuit of happiness for a federal statute to be able to put a person on your boat to overlook your work.
Well, the basis of if we set aside who pays for it, the basis for federal monitors is federal fishing law. And the idea is Congress has the power to regulate interstate commerce, which fishing is considered to be. And so it's passed laws about, you can only fish during certain times a year. You can, only catch a certain number of fish or pounds of fish or different seasons. You can't catch them during their spawning season. They can't be undersized. All these various fishing regulations to regulate interstate commerce, to make sure that the fish don't die off, and whatever other good public policy reasons they might have. Well, to enforce those rules, it kind of makes sense to have monitors. It's hard to enforce them otherwise, perhaps. Maybe, the challenge could be we don't want to have a person on here. Why don't we just have a video camera looking at everything we're doing or something like that? So it's not so strange to say that if you accept the propriety of the fishing regulations in the first place, which is a separate discussion. But if you have those, then there needs to be a way for the government to enforce that. And then the question becomes, are they doing it, with the least restrictive means or a reasonable means, or what is the standard that should be applied in those contexts? What is the penalty for violation for that matter? Do you, just lose your catch for that day? Do you pay a fine? Do you get imprisoned? Is it a criminal statute? So there's all of these sorts of considerations. But again, the idea is if we have a government and the federal government does have the power to regulate interstate commerce, and if it's not interstate, then the state will be regulating and could be doing the same thing. Then it's a matter of enforcing those laws.
It's quite a slippery slope for the federal government to be empowered for using, and of course, Commerce Clause, pretty famous. Slippery slope for that to be out of the state's hands and be into the national government's hands, as we've seen infringed rights consistently like this.
Well, I mean, in this context, I'm not sure the fisherman cares whether it's a federal monitor or a state monitor. The type of infringement is pretty much the same.
Well, the fishermen at care, but as far as the success of our system of government, certainly makes a difference in the way that the power is wielded and where the power comes from. Because if the states of the laboratories of democracy, sure, state might get it wrong, but when we give that power to the national government, stakes are raised, and then we may see that as that power is given, then the administrative state needed to enforce that power will then necessarily be created. So which came first, the power being delegated to the administrative state, or the administrative state sucking up that power? I would say is probably the first. Um, but so some of these discussions, we were reading the Supreme Court's decision, and these words like reasonable. It is hard for those just thinking from a constitutional mindset, um, parse through that language, not as non-lawyers.
Um, okay, I'm sorry. What's the question?
It's just a comment. Jordan, you can go with your
Well,
question.
federalism is important to protect liberty, so that the federal government is one of enumerated powers, whereas state governments have background powers to make laws to protect the general health, safety, welfare of the citizenry. Fisheries, I don't think is a good example of uh, violations of federalism necessarily, unless you're talking about, ponds and lakes within states. But here we're talking about ocean faring, fishing operations, and fish obviously don't respect state boundaries. So it's not. I don't think it's unreasonable to think of fisheries as, at least, oceanic fisheries, as being interstate commerce, as opposed to, for example, a farmer growing some crop in his backyard for his own consumption, which is a famous Supreme Court case from the 40s that the court determined to be part of interstate commerce.
I'm a little, I'd like to ask about the effect of the Supreme Court cases on all citizens, more so than, just the particular case, like such as the Ohio versus the EPA. Um, I don't think it's, I don't think it's quite so visible for everybody about how much those cases, such as that one, and for states trying to keep up with these guidelines, how visible it is for me, just an American, how that affects me. So could you just talk about that a little bit? And, there's so many, green initiatives, which whether you are for it or not isn't really the case. It's just whether it's forced upon you or not. Um, and those, it's kind of just talk about the trickle down effect of states trying to keep up with regulations, and how the states then force you to keep up with the regulations that they've agreed to, or are inhibited by.
I don't know if is your question about some obscure cases that have a lot of impact. That's certainly true, particularly in the administrative law realm, because some regulation from an agency you've never heard of, or that doesn't get a lot of publicity because it's very technical, does affect, say, the price of food that you buy in the grocery store, or something like that, or the price of the car that you buy, or how much your gas costs, or something when you fill up. That's certainly true. Ohio versus EPA is a case about interpretation of the Clean Air Act, which we've talked about in other contexts. But there are a lot of, when people think of the Supreme Court and people think about constitutional law, it's always kind of culture war issues, abortion, guns, affirmative action, these big sexy topics. But I think you're right that there are a lot of cases that have a significant economic or societal impact that don't get talked about. It's hard to explain. Don't make the front pages. Even this Loper Bright case, which overturned the Chevron Doctrine, is not being talked about, or wasn't until now we're kind of in a weird news cycle where there's a world historical event happening every day as we record this event here. But at the end of the Supreme Court term, everyone was talking about immunity and all these other things, and not the revolution in administrative law, because these things are harder to understand than kind of a basic debate over the freedom of speech, and should a student have that right in this context, or who gets to regulate abortion, or when do rights attach to a baby, or can you use race for this purpose, or how does an allegation of sex discrimination in a different context, those are much more understandable. But when you get with these issues that I've been trying to break up to make them more explainable, it's hard. And you're right, Ohio versus EPA. I don't know how big of a case it's going to be at the end of the day, but there are big regulations coming from every administrative agency, regardless of which party controls the White House and is supposed to control the bureaucracy.
Okay, thank you. It is going to pass back to Tova for some audience questions.
Thank you so much.
Tova, I just want to say that James Madison, Federalist Paper 62, if the laws are so voluminous that they cannot be, if the laws are so voluminous they cannot be read, or so incoherent that they cannot be understood, and I'm paraphrasing now, so of no avail to elect men of your own choice, if the laws are so voluminous and you're incomprehensible. And I think that's kind of what Julian Jordan and you, Ilya, are talking about. It's like knowing what all these laws are. And when you really feel how laws affect you is when you want to start a business. You know what I mean? Or you're like, what? I have to do what? I have to do this. I have to do that. Oh my gosh. And then it stifles creativity, and it stifles people wanting to hope and ingenuity. And I think that's part of the thing, where there just needs to be balance, right? I just think there needs to be balance. We just need balance. But James Madison, he did talk about this, that the laws are so voluminous they can't be read, or so incoherent they can't be understood. Right, Ilyia? He talked about that.
Yeah, and back then the laws were a small percentage of what they are now.
I know. All right. Okay, just had to say that.
Yeah, thank you so much, Janine, for that additional context. And now I want to acknowledge all of the students and teachers who are listening in today. So Kathy Bradford has 2 students from Bradford Christian Homeschool Academy, so thank you for being with us today. And D'Angela Hines has 3 students from Emerald Coast Christian Academy. I feel like I always hear that name on our podcast, so thank you so much for tuning in again. So I want to ask some of the audience questions that have been coming in. You've gotten a lot. People are very interested in what we were talking about. So to start off, I want to ask Bill Conk's question. He's asking about state constitutions, and asks, do any state constitutions have provisions requiring administrative rules or codes created by a bureaucratic agency be approved by the state legislature, and governor before taking effect?
I don't know them off the top of my head, but yes, that does exist. That either that major rules as defined by something that affects X million dollars, or some level of social impact as determined by the relevant official, have to be approved by the legislature, or they don't go into effect until a certain amount of time has passed, such that the legislature has a chance to disapprove them. Those exist. For that matter, this issue of judicial deference, the Chevron Doctrine at the state level, about half the states actually, either by legislation or by their own courts, have prohibited or never had the Chevron Doctrine. So all the states have administrative agencies, of course, that we talked about, the DMV earlier, but they're, state education departments, the cabinets that all the governors have, that lead the various state departments. There are state bureaucracies, and these same sorts of issues come up at the state level. And yes, states have dealt with them in different ways than what exists at the federal level.
Great, thank you. And then Julian Smith asks, does this case only apply to situations going forward and not retroactive? And I guess my addition to that question is, will there be challenges to existing rules that have been determined by administrative agencies in the past, or is this just like all rules going forward that are instituted?
It's so everything that's this ruling in Loper Bright does not give license to reconsider past rulings that were based on Chevron deference. Now, if there's some new challenge to an old rule. I mean, there are rules. You know, if there's some rule that's 50 years old and it's never been challenged, it might be too late to challenge it now. Who knows? Except this other case, Corner Post, puts a wrinkle in that. But anyway, no, this is for future lawsuits or currently ongoing lawsuits, litigation cases that have not been that don't have a final judgment.
Great, thank you. And James Klinger, who's a frequent contributor to our podcasts, asks, is the Supreme Court going to take on our deference, AUER? I might be mispronouncing that, but after addressing Chevron deference, and could you explain what our
Yep.
deference is?
Yep. So our AUER deference involves deference to agencies for reinterpretations of their own regulations. So not they're for the first time looking at the Clean Air Act and figuring out what that means. That's what we've been talking about this whole hour, Chevron. Our is an agency has given some sort of interpretation to its own regulation, and it's going to change that interpretation. The court decided this, 5, 6 years ago in a case called Kisor, Kisor. It did not overturn that kind of deference, but it limited it in certain ways, like the agency's change of policy or change of interpretation has to be based on legitimate expertise. That is the science, the economics, something like that, not just, lawyers, because judges are as good lawyers as agency lawyers are. It has to be based on a legal interpretation, not just, we decide we don't like that policy, so we'll change it in that way. There's all these kind of ways in which that kind of deference was limited. So I don't think the court is going to revisit that decision, but it does show that the court treats agency interpretations of the law of Congress's output differently than courts treat agency reinterpretations of their own work.
Great, thank you so much. And then E. David Sawyer asks, is there not also a judicial branch component to the big issue of the appropriate scope and authority and size of the administrative state, along with the discussed legislative deferment of roles, a deferment of roles? There are hired employees of numerous agencies acting in administrative, judge, and other similar functions to partially carry out the arguably large and broad functions that over centuries have been increasingly delegated to those mostly big agencies.
So these quasi-judicial operations within agencies can be suspect. The Jarkissi case that I mentioned at the outset involving the Securities and Exchange Commission, the SEC, the court said that these administrative adjudications are not good enough to satisfy the Seventh Amendment right to jury, for example. So in various agencies where someone is being prosecuted for what the court said was for violating some rule that has some parallel to something that we knew about at common law. So, for example, in the securities case, that means fraud. I'm defrauding you. I'm representing that this pen is worth $10. It turns out it's worth 10 cents. I've defrauded you. Well, similar sorts of things with securities, stocks and bonds and other things like that. And so if the SEC is going to investigate you for securities violations, that's like common law fraud. You have to go to a jury. Certain kinds of agencies do have those internal administrative law judges, but there's no common law analog. Social Security, for example, government pensions. And so there, the administrative law judges, I think, are not going to be disturbed by the court's ruling.
Great, thank you. And then Lewis White asks, the size of the government is proportional to the size of the deficit spending. So, could this case be used to reduce the size of government agencies?
It's a good question. I don't know if it's necessarily tied to it. Like I said, nobody's going to lose their job because of this decision. Those are more decisions for Congress to decide how much money to give a given agency. And Congress can give agencies lots of money. For example, even if agencies don't pass any new rules, they might enforce them more. So, the IRS recently got more people more agents to enforce the tax laws. So even if the tax laws don't change, don't get stricter or whatever, if there are more enforcers, that enforcement is going to cost more money. So does that mean the government's grown? Its budget's grown, and you're talking about deficit here. So it depends on what measure you're really thinking about.
Makes sense. And I'm sure there's a lot of open questions too that time will tell. And then for the last question, James Klinger again asks or mentions that this controversy is often cast as a shift of power away from the agencies, but it seems to me that the Roper decision largely pulled power away from the president, since the president appoints most agency heads and is head of the executive branch. So what do you think of that argument?
I mean, ideally the president is supposed to be in control of all this stuff, but the bureaucracy has gotten so large that there's been separate litigation over presidential control over agency heads. And I don't mean cabinet appointees, but the head of the EPA, the Securities and Exchange Commission. It's a commission. There's 5 commissioners. So there have been litigation over how they can be removed only for cause, meaning if they've done something wrong, or if the president just wants to, there was a majority of Democrats, he wants to replace them with Republicans, or vice versa. And the answer is it depends. So for practical purposes, what this ruling is going to do is cabin the agencies. How much control the president has over the agencies is a separate question.
Great. Well, thank you so much. That takes us right to the top of the hour. So, Ilya, thank you so much for being on. Yeah,
I
yes.
have a quick question. I have a quick question. Ilya, I don't know the answer to this question. These heads of the agencies that are appointed by the president, they don't have to have a Senate
They do.
approval.
They do.
They do.
Yeah.
Okay, that's interesting. Okay, so whoever they appoint to be the head of the agencies, the Senate has to approve.
Yeah.
Interesting. Thank you. Didn't know that. Okay, Toma, back to you. Thank you, Ilya.
Yes, all to say thank you so much for being here. We hope to have you back soon. And thank you for making time, and thanks everyone for joining us. We'll see you back here next week. Spread the word. Thank you.